We are recording.
All right, thank you very much. Good afternoon. The Appellate Court for the State of Connecticut is now back in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel are advised that to the extent that there is statutorily protected parties and or information here, that you take extra care not to identify that protected information. I would ask that everyone participating in the hearing identify themselves, starting with the judges. I am Judge Elgo.
Justice Harper.
I'm Judge Cradle.
Now for the, I'm sorry, go ahead, counsel.
Good afternoon. My name is James Riley. I'm with the law firm of Whitman, Breed, Abbott & Morgan. We represent the plaintiff appellant in this matter, and Ms. Zealand is also with me in the conference room.
All right, thank you.
Good afternoon, Your Honor. My name is Ari Hoffman with the law firm of Cohen & Wolf, and I represent Scott BALBER, the appellee.
All right, thank you very much. So for the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you're experiencing any difficulties hearing or seeing the other participants. If you should lose your audio or video capability, please log out and retry the Teams link that you were sent in order to participate in this event. In that case, we will pause recording the proceedings. All participants must keep their video on and remain in view out of respect for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt you if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Cradle has kindly agreed to be our timekeeper and will give you a 2-minute warning sign and indicate when your time is up. And so we will now hear the matter of Zealand versus Barber, docket matter 43650, and counsel, you may proceed.
Thank you, Your Honor. And yes, I would like to reserve 5 minutes for rebuttal.
All right, you've got it.
Please the court. My name is James Riley. I represent plaintiff appellant ELISE Zealand in this matter. The principal issue on appeal is whether in the circumstances presented here, the trial court committed reversible error in concluding first that Ms. Zealand's interest in the Westport property and the artwork at issue was minimal, as that term is used in section 52-500A of the Connecticut General Statutes. And if not, in other words, if the trial court did not commit error, whether the court erred in concluding that the sum of $25,000 constituted just compensation to her for those assets, again, as that term is used in section 52-500A. That amount represented less than 6% of the equity in the home. The trial court found that the property had a fair market value of $1.2 million and was encumbered by a $765,000 mortgage at the time, leaving about $435,000 in equity. And it is a sum for which the court offered no calculation or explanation as to how it had reached that particular amount. We believe the court's decision was erroneous on both points.
Is there a motion for articulation, counsel, with respect to your claim that there was no development with respect to how it came to that determination?
There was not, Your Honor. We believe the court's decision was erroneous for two reasons, which are related. First, that the court's decision failed to account for the fact that at the time they acquired the Westport property in 2012, the parties were 4 years into a cohabiting relationship, with Ms. Zealand caring for their 2-year-old child, and when Mr. Balber had custody of them, his 2 children from a previous marriage. And during that, at the time they acquired that property in 2012, their conduct, their words and their actions both manifested an agreement and understanding that they were co-owners of the property in the true sense of the word. It was undisputed, and the trial court specifically held that when my client learned that the purchase of the Westport properties to be titled in Mr. Balber's name only. She objected and insisted that she be identified as a co-owner of the property, that she hold title equally. In other words, and actually, in fact, according to Mr. Balber, she threatened to leave him if she was not made a co-owner. That demand did not come out of left field. It had been a significant talking point between the parties for some time, which is not surprising considering that my client had suspended her law career to raise their family together. And
may I just interrupt again? The standard of review here is it an abuse of discretion? Would you agree?
It is, Your Honor, with respect to the issue of the court's determination of the parties' respective ownership interests in the property at issue. To the extent that the court is considering or is construing 52-500A, either with respect to the construction of the term minimal interest or just compensation, then in that respect, the court's review is plenary.
All right. And are you in? Oh, I'm sorry.
No, you go ahead. I'm sorry.
Are you still pursuing your claims with respect to evidentiary error?
We are, Your Honor.
Okay. All right. Go ahead.
We are. I'm sorry, Justice Harper.
Counsel, was there any attempt to negotiate an agreement?
I'm sorry, Your Honor.
Was there any attempt to negotiate an agreement?
I don't believe so, Your Honor. You mean with respect to, you mean
The
by way of
property?
settlement?
Yes, settlement agreement.
There have been discussions between counsel at times, yes.
Okay.
And there was a discussion at following a pre-argument conference. There were discussions.
So there were discussions about reaching the settlement agreement.
Yes.
Okay, thank you.
As I started to say, the demand that my client be a co-owner of the property in the true sense of the word, it didn't come out of left field. This had been an issue, as you would expect, for Ms. Zealand, considering that she had suspended her legal career. And in fact, 2 years earlier, when she expressed to Mr. Balber that she was feeling financially vulnerable because of that fact, he sent her a very thoughtful email in which he said to her, I don't want you to ever feel that way. For avoidance of doubt, the job you are doing, taking care of the kids, keeping the house, etc., is the most important job, and I recognize and appreciate that. Every dollar I have is your dollar. Whatever I have is yours. When my client insisted on co-ownership, when she agreed to be jointly and severally liable on the mortgage debt, she didn't do so in the belief that this was some abstract or illusory interest that was subject to a reduction by 95%. Sorry, Your Honor.
Counsel, you said it was an email, a thoughtful email that was sent?
Yes.
Was that ever introduced into evidence?
It is, Your Honor. Yes, that's part of the record.
Okay, thank you.
Yes. And Mr. Balber, at the time and I think this is also probative too, when she became a co-owner of the property, in other words, when they closed on the property, he sent her an email with a copy of the mortgage deed attached to it. And in it, he said, here you go, big shot. And he testified as to what he meant when he said that. And what he testified to was, and the here you go, big shot was kind of a joke, since she had made such a big deal about wanting to have her name on the deed of the house and how important it was to her. So that's what it was a reference to. Here you go, big shot, jokingly, like, here's what you wanted. Well, there's no question what my client wanted. She wanted to be an equal co-owner of that property. And there's no question that Mr. Balber understood that's what she wanted. And yes, Your Honor.
Can you clarify again, how long were they together in that house?
They were together in that house for 4 years. They bought that house 4 years into an 8-year relationship. To that point, Your Honor, I think it's important to note that it's clear they were in a married-like relationship. They cohabitated together for 8 years. They had a child together. As I indicated, my client was helping raise Mr. Balber's children from a previous marriage during that period of time. When you look at other cases, at similar cases involving unmarried cohabitating couples, the result here just simply cannot be reconciled with the decision in those cases. And I would direct the court, for example, to the DeSerto versus Jones decision, which was a case it was a decision by Judge Arnold in Bridgeport, which was affirmed by this court in 2008. And the facts in that case are remarkably similar to what we have here, insofar as in that case, the parties were together for 7 years. Here it was an 8-year relationship. In that case, the jointly owned property was, they held together for 5 years. Here it was 4. In that case, just as was the case here, the trial court found that there was no agreement between the parties with respect to what would happen to that asset if the parties separated. In that case, the court found it was probative, that it was actually dispositive of the with respect to the equitable distribution of the proceeds upon sale, that there was no request made for reimbursement of the mortgage payments, the insurance, the maintenance costs. Exactly the same as there was in this case. The only difference is, yes, Your Honor.
Oh, tell me what the only difference is, and then
The only difference is in the DeSerto case is that the couple weren't raising a child together. They weren't raising a family, and as well as the fact that the trial court found when the trial court actually carved out when it decided on the equitable distribution of the sale proceeds, it carved out the down payment that Mr. Jones had made towards the purchase price. And it didn't divide that between the parties because it said at the time they acquired the property, they intended to keep their finances separate. The trial court noted that in that case, the plaintiff, Carol DeSerto, had sold a condominium but did not use the sale proceeds to purchase their home in Easton together. And in fact, here in our case, by that point in time, my client had had a child. She'd suspended her legal career. And their funds were joined together in joint accounts. She'd actually spent her savings in connection with the 3-bedroom apartment that they had rented in New York. And the reason they needed a 3-bedroom apartment was so that they could help care for his 2 children from a previous marriage. So here, the only factors that are different from the DeSerto case and our case actually militate in favor of a greater distribution of the proceeds to my client. You know,
in the DeSerto case, did the party seeking an interest, was that person also professionally employed or employable?
She was employed. Yep, oh. She was.
I guess my concern about comparing to other cases, to the extent that it's an abuse of discretion standard, is that there's no formula, really, right? Because it's inherently not part of an abuse of discretion standard, and so the factors and the question is just really, is this in the realm of the discretion of the court? And to try to get into this place where we, as a reviewing court, are going to start looking at other superior court cases and say, well, this is, so much like X that, now we have this standard, which really isn't what the abuse of discretion standard is about, right?
And that's a point well taken, Your Honor. Here it's different, because here I think the trial court made 2 errors that really require reversal. And I started to talk about the first one, which was that to the extent that the trial court failed to properly account for the fact that at the time the parties acquired the property, there was an understanding, there was an agreement that they were owning that property as true co-owners, each holding an equal, undivided 1/2 interest in the property. And nothing that happened after that was a surprise or would have changed that. In other words, my client wasn't working. She was raising their family. So at that point in time, everyone knew that she was not going to be contributing to the mortgage payments, the insurance, et cetera. Just as in DeSerto, which the court found was dispositive, there was no request made by Mr. BALBER for reimbursement for those costs. So that's point one. The second point is that in our case, I think that the trial judge got it wrong insofar as he indicated that my client's non-monetary contributions were only relevant insofar as they related to the acquisition or the maintenance of the asset in question. In other words, what the trial judge said was that he was not going to admit evidence regarding her contributions to the relationship generally, and that he would only admit evidence insofar as there was a nexus between those non-monetary contributions and the acquisition of the asset or the cost to maintain the asset. And that's not the law. But the law is the opposite of that. What this court said in DeSerto was that Although cohabitation alone does not create any contractual relationship or, unlike marriage, impose other legal duties upon the parties, where the parties have established an unmarried cohabiting relationship, it is the specific conduct of the parties within that relationship that determines their respective rights and obligations. So my clients, the fact that she had suspended her career, the fact that she was raising their children, that all of those factors should have been not only admitted into evidence by the court, but also taken into account in the court's decision. Without that, there is simply no way to reconcile the results in this case with the results in other cases where you have, thank you, unmarried cohabiting parties, such as, I'm sorry, Your Honor.
What about the extent to which the court had some credibility concerns with respect to your client? And to what extent does that fairly figure into the court's discretion?
I don't think that actually factored into the decision. What rings clear to me, Your Honor, is when you read the court's decision, it is that he was only considering the parties' financial and non-monetary contributions to those particular assets. And he thought he was without authority to consider the non-monetary contributions to the relationship as a whole. And as I said, without that, it's simply impossible to reconcile the result here with what you see, for example, in the DeSerto case, or what you see in the Adamson versus Merrill case, which we also cited. That was Judge Hartmere in that case, in which he specifically references that he was considering in determining that it was not a minimal interest, the fact that the parties lived together and cohabitated together in a relationship. And he specifically said, I'm considering the nature of the relationship and the length of the relationship. You know, all of the cases in which the court, and this court hasn't really delved into the issue of what's considered a minimal interest under that statute. But there's a common thread that runs through the cases in which a minimal interest has been found. And that is that the owner of the property whose interest is being challenged is a relative stranger to the property. That is the opposite of what took place here. My client was in a married-like relationship with the defendant in this case. They were raising a family together, and they were residing in this property together. In fact, my client spent more time at this property than the defendant did. I see that my time is up, and thank you.
All right, thank you. Attorney Hoffman?
Thank you, Your Honors. I submit that the law and the evidence show that the trial court and Judge Kavanewski did not abuse his discretion in this case. His rulings, his decision were supported by the law and the evidence and included the consideration of the witness's testimony and their credibility. I want to highlight some evidence that is undisputed or was uncontested. This case is about an unmarried New York couple's weekend getaway house in Westport. The individuals in this couple were both well-educated lawyers from highly reputable schools who have highly reputable employment backgrounds. When Mr. Balber and Ms. Zealand met, they had both been divorced. Mr. Balber shares custody of 2 children from a prior marriage. After dating for a couple of years, Mr. Balber and Ms. Zealand had a child. In 2010, they were never married, and shortly after they got engaged, Ms. Zealand testified that she had misgivings about the marriage. In 2012, or about getting married, in 2012, there was a decision to purchase the Westport home as a weekend getaway. It was not a primary residence. It was never contemplated that it would be a primary residence. Their primary residence was in New York City. Mr. Balber paid and continues to pay every penny with respect to the Westport home. Specifically, he paid $250,000 towards the purchase of the property. And in addition, Mr. Balber paid and continues to pay every expense related to the property, including mortgage payments, taxes, insurance, utilities, maintenance, and so on. The property's total carrying costs have been approximately $100,000 per year since it was purchased in 2012. So from 2012 through the date of trial in May 2019, Mr. Balber paid approximately $900,000 towards the property, including the down payment. Nearly all of the property's equity at the time of trial was attributed to Mr. Balber. In particular, there was $435,000 of equity at the time of trial. Mr. Balber paid $410,000 of that through the down payment and the ongoing mortgage payments. Only $25,000 was due to the market increase. Ms. Zealand was awarded as compensation the entirety of the amount that was attributable to the market increase. Mr. Balber performed non-monetary functions related to the Westport home too. Given that it wasn't a primary home, there actually wasn't much testimony on the typical day-to-day housework activities because there really wasn't any. But when needed, he has been the person to meet with landscapers and contractors and other maintenance people. He also has done lawn work for himself. However, she did testify, Ms. Zealand did testify that she was at the property for some of the repair work, and the decision does note a few non-monetary contributions that she did make. Since 2016, the parties' relationship ended, or after the parties' relationship ended, Mr. Balber has exclusively used the Westport home and has continued paying everything. With respect to the artwork, which really has not been raised much, so I'll just speak about it very, very briefly. This is the only personal property at issue. Mr. Balber purchased the Gibson artwork from his longtime friend and client. The client offered it to Mr. Balber at half of its value due to their long-standing relationship. Mr. Balber purchased the artwork with his funds, and Ms. Zealand never had any interest or signatory, never had any interest in the artwork. Also, it is uncontested that during their relationship, Mr. Balber fully funded their Ms. Zealand's lifestyle. What was conflicting or had disputed testimony were certain understandings between the parties, most importantly as to what would happen with the proceeds of the house when the parties sold it. However, that conflicting testimony was before Judge Kavanewski, and he chose to place whatever weight, if any, on the parties' supposed intentions. In at least one instance in the decision, he expressly stated that Ms. Zealand's testimony was, and I quote, somewhat incredible, particularly when she did not even know whether or not she was on this mortgage. In another instance, he said that her testimony on valuation of the artwork was simply not credible. And I submit that the fact that he actually wrote in his decision that he found her to be not credible more than once is relevant to the overall outcome of the case. It is the trial court's function to weigh a witness's credibility and use its discretion at arriving at an equitable result. I'd like to address the first issue, which is the minimal interest issue that Attorney Riley discussed. Pursuant to Section 52-500A, a court is within its statutory right to rule that based upon the totality of the evidence, an owner has a minimal interest in the property, that a sale would not promote the interests of the owners, and that a court may order an equitable distribution of the property with a payment of just compensation to the owner of the minimal interest. It cannot be overemphasized that this section does not provide any specific thresholds or means tests in defining minimal interest. If the legislature wanted to include a threshold at which a court would have no discretion, it would have, and it didn't. And there is no ambiguity here. The plain meaning rule would apply. The trial court has discretion, and there is no specific percentage of ownership that would militate against a finding of minimal interest. Nothing other than the statute needs to be or should be considered. However, if we do look at the legislative history, the state legislature made it clear that the court must use its discretion based upon the totality of the evidence to balance the equities. And we have representations from Representative Stone and Representative Farr that were briefed that talked about the express basis for why they did not include a percentage in the statute. Ms. Zealand is attempting to write into the statute something that the legislature expressly decided against, as evidenced by their discussions and ultimately, and most importantly, the statute itself. So we know the court has discretion regardless of the percentage ownership. Then the issue is whether there was an abuse of discretion. The court must balance the equities and review various relevant factors with respect to the property, such as the amounts each paid prior to or closing on the property, whether each party was essential to the purchase, amounts each party paid toward the mortgage and the taxes and the insurance, and the use of the property by each party, and the party's intentions with respect to the allocation of any net sale, whether this was a primary residence, and the non-monetary contributions. So with respect to, again, the monetary contributions, Mr. Balber paid everything. Ms. Zealand paid nothing. With respect to the non-monetary contributions, there was plenty of testimony as to the alleged non-monetary contributions, and the court had in its discretion to give the proper weight in accordance with the testimony. Attorney Riley briefly raised this July 21, 2010 email, which I want to touch upon because in large part, Ms. Zealand's case largely rests upon that one email. This email predates the purchase of the property by more than 2 years, and he did pay. Mr. Balber did pay for her living expenses, and the evidence shows that he facilitated that by adding her name to the bank account and funding it for approximately 6 years during the entirety of their relationship or their engagement. While the email reflects Mr. Balbert's generosity to Ms. Zealand during the relationship, this email was not intended to be, nor can it be reasonably construed to be, a lifetime commitment entitling her to an equal share of his assets. The trial court's decision to place weight on the actual monetary and non-monetary contributions and not on Ms. Zealand's version of events is unsurprising here. It was in Judge Kavanowski's discretion to weight the testimony accordingly. So, Your Honors, given the complete imbalance in the parties' respective economic and non-economic contributions in regard to the property, the fact that Mr. Balber in no way needed Ms. Zealand to purchase the property, the fact that she has always had little, if any, connection to the property, the fact that found in multiple instances that her testimony or reactions were not credible or reliable, the fact that this was not their primary residence, the trial court did not abuse its discretion in deciding that Ms. Zealand's interest in the property is minimal and that a sale should not be forced. And also on this, the court did not abuse its discretion in forcing a partition sale. It found that there was ample equity in the property and that selling a property via partition sale would have attendant costs and expenses. It would be sold under distress, and this would not benefit the parties. A decision to attempt to preserve the equity in the property and not force a distressed partition sale, especially in light of the parties' respective interests in this case, was not an abuse of discretion. I'd like to move forward with the second issue, which is the evidentiary objections. Ms. Zealand is no ordinary pro se litigant. She's no ordinary lawyer, I would submit. She's admitted in both Connecticut and New York. She graduated from Columbia Law School. She's an experienced litigator, having worked at prestigious large New York law firms, and she has also served as corporate general counsel. Mr. Balber filed a motion in limine seeking to preclude narrative testimony in advance of the trial. The trial court, over objection and after overruling Mr. Balber's motion in limine, allowed Ms. Zealand to give narrative testimony without requiring her to proceed with a question and answer format. The trial court and Judge Kavanowski could have easily decided otherwise, especially in light of Ms. Zealand's education and her skills. In allowing Ms. Zealand to offer many hours of narrative testimony, the trial court allowed Ms. Zealand to testify concerning her purported contributions, albeit most of which were unrelated to the property and most of which were absolutely disputed by Mr. Balber. She did testify about her career. She did testify about circumstances in which she met Mr. Balber. She did testify that she paid for certain items. She did testify about her purported child care. This testimony, there was a lot of dispute concerning the nature of and the extent of her taking care of their child. She did testify that she assisted Mr. Balber in his career in various ways, and even well before the purchase of the property. She had all of this evidence came in. It was all disputed, but it came in, and it also had testimony from Mr. Balber stating otherwise. The trial court, however, did properly strike Ms. Zealand's narrative when it went so far afield, or when it was cumulative. And given her narrative testimony, the court had the benefit of hearing the proffered testimony before the few occasions where Judge Kavaniewski struck the testimony. And again, when Judge Kavaniewski did strike the testimony, it was entirely warranted. It was either irrelevant or cumulative. She testified about her hosting of events well prior to the property's closing. At some point that was stricken. She testified about her perception that she advanced his career prior to the property purchase. That was cumulative. She had already testified to that. She testified that she attended anniversary parties. That was stricken. There needs to be some nexus, and Judge Kavaniewski said this. There needs to be some nexus between contributions and the property at issue, even if it's just a temporal nexus. And while the trial court gave extraordinary latitude to Ms. Zealand, allowing her to speak at length in narrative form, it properly and in its discretion set certain needed boundaries. What hasn't, well, also, even if this court were to conclude that the evidence should have been admitted, any such error was harmless. The trial court, both on the record and in its decision, made clear that it understood and appreciated that Ms. Zealand's claim relied on her non-monetary contributions. The evidence excluded by the trial court, which was cumulative, which was not related to the purchase, care, or upkeep of the property, and which is in the transcript, which would not have changed the result. Another issue that was raised on appeal is Ms. Zealand moved the court to reconsider its ruling, which required her to convey the property to Mr. Balber when she was still on the mortgage. And the court granted her motion and ordered Mr. Balber to ensure that she be released from the mortgage, and that if the mortgage is not released within 120 days, that property would be sold. Ms. Zealand now effectively appeals the court's decision granting the relief she sought. As we stated in our brief, such a challenge epitomizes the saying, "No good deed goes unpunished." Ms. Zealand ignores that the trial court, in adjudicating a partition claim, is a court of equity. The trial court correctly used its discretion to arrive at a decision that addresses Ms. Zealand's concern that she would remain liable on the note and mortgage when she no longer has an ownership interest in the property, while at the same time not wanting to force a sale of the property, which would penalize Mr. Balber. In every facet in this decision, and in this case, as most recently seen in the corrected memorandum of decision, Judge Kavaniewski balanced the equities here. And finally, I would like to talk about the lump sum payment. The trial court is not required to employ a mathematical formula in arriving at an award of just compensation. The trial court's findings amply support the compensation award. They were not married. This was not their primary house or residence. Mr. Balber funded Ms. Zealand's life for 6 years. He paid hundreds of thousands of dollars into the house. She did not contribute anything financially, contributed very little non-monetarily, and their perspectives were very different at trial about their understandings. And just because the court didn't agree with her, that doesn't necessarily correlate to an abuse of discretion. And there is a basis for the $25,000 when the equity, only approximately $25,000 of the equity in the property was attributable to an increase in the market value as of the trial, while the balance of the equity, the $400 and close to $10,000, was directly attributable to Mr. BALBER. And again, although the trial court provided a more than sufficient factual predicate to justify its award, Ms. Zealand never filed a motion for articulation. Deserto was raised as a case, and I'd just like to talk about it very, very briefly. That case is distinguishable. The plaintiff and the defendant there purchased this that as a primary residence. Here, this was a weekend getaway that was occasionally used. They lived there. Deserto and Jones lived there for about a third of the time more than here. And the parties there had known each other about 10 years prior to buying that residence. There was no dispute there about the parties' agreement that they would share in the ownership of the party and the property. Here, there was a dispute about the ownership. And there in Deserto, interestingly, and I think importantly, the property was sold prior to trial. The trial court did not have to decide the minimal interest issue. In Deserto, they split the amount that was attributable to the increase in the market in the value. Let me say that again. They split the amount that was attributable to the increase in the market value. Here, Ms. Zealand received 100% of it. And I think that the important takeaways from Deserto is that the appellate court affirmed the trial court's wide discretion in finding the equitable interest of the plaintiff and defendant. There's no two cases the same. No two cases the same. Every fact scenario is very, very different. And Judge Kavanewski, after a 3-day trial, weighed the testimony, weighed the evidence, weighed the credibility, weighed their relationship. This is not a marriage. This is not a divorce, and came to this decision. And that's what Deserto said. The court must consider all pertinent factors, including the credibility of the witnesses. And Deserto v. Jones affirmed that 46B-81, which is the assignment of property in divorce case, is not applicable in a partition case. So, Your Honors, I do believe that there was no abuse of discretion with respect to any of the issues on appeal, and that Judge Kavanewski's decision should be affirmed in its entirety.
All right. Thank you very much. Getting a little bit of feedback. Somebody. All right. Perhaps if Attorney Hoffman, if you would mute your mic, and thank you. And Attorney Riley, you have, I believe, 5 minutes is what you reserved. All right, go ahead.
Thank you, Your Honor. So, Attorney Hoffman states that no two cases are exactly alike. That's true. What distinguishes this case from the other cases is the fact that the trial court here made two significant errors. The first being that the trial court believed it was not able to accept evidence of non-monetary contributions other than with respect to the acquisition and maintenance of the assets. And that was wrong as a matter of law. And the second was—
Attorney Riley, with respect to that issue, though, at least, and obviously we would be obligated to look at the record and the transcript, and given the recounting of Attorney Hoffman with respect to your client's narrative testimony, where it sounded, notwithstanding what the court said, there was a lot of testimony that was offered with respect to non-monetary contributions. Correct?
Certainly there was some testimony relating to it, Your Honor, but I've got in front of me the portion of the transcript where the court said, in my mind, there needs to be some nexus between what you did and the purchase or carrying of this home, so to speak. In other words, and it's not just with respect to the evidence. That was the basis for the court's decision. In other words, that's why there's such an enormous disconnect between the decision here and other decisions that have evaluated the parties' ownership interests in jointly owned property when they are a cohabiting unmarried couple.
Well, and let's look at that, because I think when I'm looking at Deserto, which is apologize. That's the reason why I was looking at this other screen. And I think Attorney Hoffman is correct in that doesn't appear as we have here, you know, a vacation getaway, right? And so to the extent that the home in Dicerta was one that appeared to be marital property in the true sense of the marital home, doesn't that make a difference here?
I don't see how the fact that it's an asset that the parties acquired and that my client acquired as believing that she was a true co-owner of the property, whether or not it's their primary residence, I don't see the relevance associated with that, Your Honor. And if I can, I'd like to address a couple of the other points that Attorney Hoffman makes. I think he mischaracterized certain of the facts and mischaracterized the Dicerta decision. One of the things he suggests that there's a suggestion that was made that the court somehow credited his client's testimony with respect to how that asset would be disposed in the event the parties separated. And in fact, what the trial court here said was that was the opposite of that. He said he didn't credit either side's testimony with respect to what would happen in the event that the parties separated with respect to that asset. He makes reference to the fact that his clients contributed all the financial contributions came from his client. That's not surprising. The parties understood that at the time they acquired the asset, and she was still made a co-owner of the property. And with respect to the amounts that he threw out, he neglects to mention that his client has had sole possession of that property since 2016. In other words, his client changed the locks on the door, or I should say changed the security code, and took all of my client's personal property and threw it on the garage floor. So the notion that he should be somehow credited for all of the money that he devoted to the property after 2016 is a fallacy, because he alone had possession of the property at that point. He threw her out of it. So, and again, there was reference made to the minimal interest standard. Again, if you look at the minimal interest cases, the cases where the courts have found that the property owner's interest in the interest was minimal, they are so disconnected from what we have here, where you have jointly owned property in a married-like relationship. No other court has done anything remotely close to what Judge Kapinowski did. To your point, Judge Elgo, yes, it is in terms of measuring the parties' respective ownership interests. It is there has to be discretion in that analysis, because no two cases are exactly alike. And in fact, if you had some sort of formulaic division that was dependent upon the parties' respective legal ownership interests, that could lead to some grossly unfair results. But what the court failed to do here was to account for the parties' non-monetary contributions to the relationship as a whole, in terms of the fact that she stopped her career, she suspended her career in order to raise their family. And I can see that my time is up, but we think that the trial court, there was a mistake, errors of law were made here, which compel remand.
All right. Thank you very much, counsel. I appreciate we appreciate your arguments. Thank you again for participating in this virtual hearing, and we do look forward to seeing you in our regular courtroom sometime in the future. We'll take this matter under advisement and recess until 4 o'clock. Thank you very much.
Thank you.
Thank you.